My name is Seth Rosenberg of the Rosenberg Law Group, and I'm here today to talk to you about professional licensure defense. Many people don't understand what that means, and hopefully you will never have to know what that means. But in essence, there are many different professions that are licensed through the state, and there are many different businesses that are licensed through the state. In fact, there's 70 different professions licensed through the state. And those licenses comes with terms and conditions. And if you violate one of those terms and conditions, or have alleged to have violated one of those terms and conditions, you may face charges from the state. And the process of how they charge you is relatively uniform. There's something called the Administrative Procedures Act, which is RCW 3405, and that governs how that process operates. There are different permutations between some of the departments, but generally it follows the following pattern. A complaint will be lodged against you, which will open an investigation. An investigator will be assigned to look at your case. They will write you a letter telling you that a complaint has been filed against you, and then they will, generally speaking, write a second letter asking you to respond to the questions that they have posed therein. Certain departments don't ask you for those questions, but most of them do. Some investigators will attempt to talk to you in person, but they really don't have a right to interview you personally, generally speaking. At the point that you're contacted by the department, it really behooves you to obtain an attorney. After you have responded to the department's inquiries, they will make a decision about whether they're going to charge you or dismiss the case. Oftentimes at this point there's an opportunity to settle the matter informally, and if a settlement can't be reached, then a statement of charges is issued, and the respondent, you, the licensee, needs to request a hearing. You should always request a hearing because it preserves your rights. There is a specific timeline within which you have to request that hearing, and if you miss it, you lose all of your rights. So the best thing to do is to immediately request a hearing and then go about attempting to contact an attorney. Even if you represent yourself, you will do better. Once you request a hearing, a presiding officer who will be appointed. This is not actually an Article III constitutional judge. This is oftentimes an employee of the very department who's charging you, or alternatively someone from the Office of Administrative Hearings. The process then follows what we would call the general civil litigation process towards a trial. There's discovery, including interrogatories, requests for production, and depositions. There's a motion practice, including motions to dismiss your case, and then there's ultimately a hearing if it can't be resolved before then, or if the motions do not resolve it before then. And that hearing, although it's informal, still has all of the hallmarks of a normal civil trial. There are witnesses, there's testimony, people are placed under oath. There's several differences. One is that hearsay is admissible, which means people can come in and talk about what other people purportedly said or did, even though those other people aren't there in court to verify that. There's generally lax rules as far as admission of evidence in general. And then the presiding officer makes a determination. Another thing that's different from the civil litigation process is the director of the department can, generally speaking, reverse the decision of the presiding officer. So even if you prevail at hearing, the department director can decide, in fact, that he doesn't want that decision to go forward, and he can then reverse that decision and find you guilty. There are appeal processes up to the Superior Court and beyond, but generally speaking, the facts are set at that hearing, and so it's best to have legal representation early on because it's very hard to appeal facts. Again, I would encourage people to contact attorneys as soon as they're notified, and not to speak to the investigator early on, because the investigators are there not to resolve the problem but to build a case against you, and what you say to them cannot be undone. We are here to help 24 hours a day, 7 days a week. It's our primary practice area, and hopefully you'll never have to contact us, but if you do, we're here to help.